Good evening, and welcome. Tonight we delve into a profoundly significant and undeniably sensitive question. Should men be constitutionally or legislatively excluded from voting on laws that specifically concern women's bodies? This debate touches upon fundamental aspects of democratic participation, bodily autonomy, and the very nature of representation. Joining us are two distinguished guests with compelling, albeit divergent, perspectives. Professor Isabel Vance, a respected academic in gender studies and bioethics, argues in favor of exclusion, grounding her position in the principles of lived experience and self-determination. Opposing this view is Senator Marcus Thorne, an experienced legislator who champions the principles of universal suffrage and the indivisibility of democratic rights. Our discussion will proceed through opening statements, rebuttals, a cross-examination phase, and concluding remarks. We anticipate a discourse characterized by nuanced argumentation and sophisticated reasoning, appropriate for a C1 level engagement. Professor Vance, you have the floor for your opening statement.
Thank you, Dr. Reed. My position is unequivocal. Yes, men should be excluded from the legislative process when it pertains specifically to laws governing female bodies. This assertion is not intended to be divisive, but rather a necessary recognition of the fundamental principle of bodily autonomy and the unique nature of the experiences these laws regulate. Laws concerning reproductive health, encompassing issues like abortion access, contraceptive availability, prenatal care mandates, and childbirth procedures, exert a direct, profound, and often irreversible physical impact uniquely upon individuals possessing female reproductive systems. This is not merely a matter of opinion or abstract policy preference, it is a matter of corporeal reality. Men, regardless of their empathy or intellectual understanding, do not share this lived physical reality. They do not experience menstruation, pregnancy, childbirth, or menopause. To grant equal voting power to those who bear none of the direct physical consequences is to dilute the authority of those whose very bodies are the subject of the legislation. It fundamentally undermines the principle of self-determination. Furthermore, we must acknowledge the historical context. For centuries, legislation impacting women's bodies has been predominantly crafted and enacted by male-dominated legislative bodies. This historical trajectory has often resulted in laws that restrict, control, and harm women, failing to adequately reflect their needs, rights, or autonomy. Excluding men from voting on these specific laws can be viewed as a corrective measure, a step towards redressing this long-standing imbalance and ensuring that those most intimately affected hold the decisive power. Finally, consider the principle of proportional impact. In any just system, those who bear the greatest burden or face the most significant consequences of a decision should possess a preponderant voice in making that decision. When the subject is the regulation of one's own internal bodily processes and reproductive capabilities, the concept of jurisdictional sovereignty over the self becomes paramount. Denying women exclusive legislative control in this specific domain is tantamount to denying the intrinsic right to govern one's own physical being. Therefore, exclusion is not disenfranchisement. It is the affirmation of a fundamental right.
Thank you, Professor Vance. Senator Thorne, your opening statement, please.
Thank you, Dr. Reed. Professor Vance presents a passionate case, but one that, I contend, strikes at the very heart of our democratic foundations. My position is clear. Excluding any group of citizens, including men, from voting on any category of law fundamentally contravenes the principles of universal suffrage and representative democracy upon which our society is built. The concept of enfranchisement is not divisible. It is not a privilege granted selectively based on perceived relevance or direct physical impact. To suggest that a citizen's right to participate in the legislative process should be curtailed based on their gender regarding any law is to embark on a perilous path towards a fragmented and ultimately unjust system. Furthermore, the notion that laws concerning women's bodies exist in a vacuum affecting only women is a fallacy. All laws, particularly those dealing with healthcare, reproduction, and family, have broad societal repercussions. They impact healthcare systems and costs, influence demographic trends, affect workforce participation, shape family structures, and involve profound ethical considerations that concern society as a whole. Men are partners, spouses, fathers, brothers, and sons. They are taxpayers who fund healthcare systems. They are members of the society impacted by these laws. To deny them a voice in shaping these laws is to ignore the interconnectedness of our social fabric and the shared responsibilities of citizenship. Moreover, the role of a legislator in a representative democracy is precisely to deliberate and vote on behalf of all their constituents, bringing diverse perspectives and considerations to bear on all matters of public policy. We are elected not merely to represent those identical to ourselves, but to engage with complex issues, weigh evidence, consider ethical arguments, and legislate for the common good, irrespective of our personal characteristics, matching those most directly affected. Legislative competence is not contingent upon sharing the specific lived experience related to a particular bill. It relies on judgment, empathy, analysis of expert testimony, and a commitment to the democratic process. Therefore, excluding men from these votes would not only undermine universal suffrage, but also fundamentally misunderstand the role of a representative and the inherently interconnected nature of lawmaking in a complex society. The indivisibility of citizenship demands equal participation.
Thank you, Senator Thorne. We now move to the rebuttal phase. Senator Thorne, you have the opportunity to respond directly to Professor Vance's points.
Professor Vance compellingly highlights the significance of lived experience, and I do not dismiss its importance in informing our understanding. However, acknowledging the unique physical realities faced by women cannot logically extend to the disenfranchisement of half the population on specific legislative matters. Lived experience informs. It does not and should not supersede fundamental voting rights within a democratic framework. Legislators are capable of, and indeed obligated to, consider diverse perspectives through empathy, rigorous examination of evidence, and reliance on expert testimony, including, crucially, the testimony of those with direct lived experience. Regarding the historical argument, past injustices and imbalances are undeniable. However, the remedy for historical exclusion is not to institute new forms of exclusion. The appropriate response is to strive for greater inclusivity, to elect more women and diverse representatives, to ensure robust debate that incorporates all viewpoints, not to carve out exceptions to universal suffrage. Creating segregated voting rights based on identity characteristics sets an extraordinarily dangerous precedent. This leads directly to my slippery slope concern. If we exclude men from votes on women's bodies, where does this logic terminate? Should childless individuals be barred from voting on education funding? Should non-drivers have no say in transportation infrastructure projects? Should urban dwellers be excluded from agricultural policy votes? The potential fragmentation of the electorate is boundless and deeply antithetical to the concept of a unified body politic. This path risks eroding the very foundations of representative government, replacing it with a fractured system based on identity categories rather than shared citizenship.
Professor Vance, your rebuttal.
Senator Thorne invokes the sanctity of democratic principles. Yet true democracy must guarantee not just procedural fairness, but also substantive justice, particularly concerning fundamental rights. The unique existential nature of bodily autonomy, the right to control one's own physical self, arguably constitutes an exceptional circumstance, where standard democratic procedures might require nuanced application to prevent tyranny of the majority, or in this case, tyranny of those unaffected. My proposal isn't about identity politics in general. It's about the singular nature of laws that directly regulate the internal workings of a person's body and their reproductive capacity. The senator's slippery slope argument creates false equivalences. Voting on education funding or road construction while impacting different groups disproportionately does not involve the state compelling or prohibiting specific actions within an individual's own body. Actions with such profound and irreversible physical consequences as forced gestation and childbirth. The physical, non-transferable nature of pregnancy and reproductive functions distinguishes this category of law fundamentally from nearly all others. It's not merely about differential impact, it's about the locus of control over intrinsic biological processes. While I concede that these laws have broader societal impacts, as the senator rightly notes, the primary, inescapable, and potentially life-altering physical impact falls exclusively on those with female bodies. This primary impact must grant primary legislative standing in this specific, narrowly defined domain. Acknowledging this doesn't negate shared societal concerns, but it correctly prioritizes the rights of the individuals whose bodies are directly subject to regulation.
We now enter the cross-examination phase. Each participant will have the opportunity to pose questions to the other. Senator Thorne, you may begin by questioning Professor Vance.
Professor Vance, your proposal raises significant practical challenges. How precisely would you define the category of laws specifically concerning women's bodies? Where is the line drawn? Does it include funding mechanisms for reproductive health care? Laws regarding surrogacy, which involve multiple parties? Access to treatments for menopause? Who adjudicates these definitions? Furthermore, how does your model account for the complexities of gender identity? Would transgender men who may retain female reproductive organs and be affected by these laws also be excluded from voting based on their gender identity? What about non-binary individuals? Finally, are you suggesting that men, as a group, inherently lack the capacity for ethical reasoning, empathy, and informed judgment necessary to legislate responsibly on these sensitive issues?
Professor Vance, your response.
Senator, the practical definition, while requiring careful legislative drafting, is not insurmountable. It would focus on laws directly regulating reproductive functions and choices. Abortion, contraception, mandated procedures related to pregnancy and childbirth. Borderline cases like funding or broader health care could be debated, perhaps requiring specific legislative committees or judicial review, but the core principle targets direct bodily regulation. Regarding inclusivity, the principle centers on the direct physical impact related to specific biological functions. The determining factor wouldn't be gender identity per se, but whether the individual possesses the biological capacity directly regulated by the law in question. Therefore, a trans man potentially affected by an abortion law could arguably retain voting rights on that specific issue, highlighting the focus on bodily reality over simple gender labels. Nuance is required? Absolutely. Lastly, I am not suggesting men lack ethical capacity. I am arguing that direct, non-transferable physical experience grants a unique and superseding standing when legislating about that specific experience. It's about legitimate authority derived from existential impact, not a judgment on male morality or intellect.
Professor Vance, it is now your turn to question Senator Thorne.
Senator Thorne, you champion the current system of universal suffrage and representation. Yet, given the historical and ongoing legislative outcomes that often restrict women's reproductive rights against the apparent preferences of the majority of women, can you confidently assert that the current system effectively protects women's bodily autonomy when cisgender men hold significant, often decisive, voting power? You raised the slippery slope analogy. Do you genuinely believe that the societal implications and ethical weight of voting on, say, highway funding are truly comparable to the state compelling an individual to carry an unwanted pregnancy to term, with all its attendant physical risks and life-altering consequences? Is the principle of bodily integrity not fundamentally distinct from general policy matters? Finally, you rely on the capacity of legislators for empathy and informed judgment. If empathy and evidence were sufficient, why do we repeatedly witness legislative bodies, influenced heavily by male votes, enacting laws that contradict the expressed needs, desires, and well-being of the women most directly affected by them?
Senator Thorne, your response.
Professor, the imperfections in legislative outcomes do not invalidate the foundational principles of democracy. The solution to inadequate representation or outcomes perceived as unjust is more democracy, not less. Electing representatives who better reflect constituent needs, engaging in robust public discourse, and ensuring evidence-based policymaking. Creating exclusionary voting blocks undermines the very system we rely on for progress and accountability. Regarding the comparison, I do not equate the substance of highway funding with abortion laws. My point addresses the principle of excluding voters based on identity or perceived direct impact. Once we breach the principle of universal suffrage for one issue, no matter how unique it seems, the justification for further breaches becomes easier, eroding the entire structure. The principle must hold, even when applied to profoundly different subjects. As for empathy and judgment, legislators are human and systems are imperfect. Disagreements on policy outcomes don't automatically prove a failure of empathy or judgment, but rather reflect deep divisions in ethical beliefs, interpretations of evidence, and constituent pressures within society itself, divisions that exist among women as well as men. Blaming male voters exclusively oversimplifies complex socio-political dynamics. The remedy lies in persuasion, advocacy, and electoral change within the existing democratic framework, not in dismantling it.
We now move to closing statements. Senator Thorne, you have the floor.
Tonight we've debated a proposal that, while perhaps well-intentioned, carries profound risks for our democratic society. I maintain that excluding men from voting on any law, including those concerning women's bodies, is a dangerous path. It constitutes a form of disenfranchisement that violates the core principle of universal suffrage, a principle hard-won and essential for a free society. We must remember that all laws operate within an interconnected society. Issues of reproductive health impact families, communities, healthcare systems, and our national discourse in ways that involve everyone. To deny participation based on gender ignores this interconnectedness and the shared stake we all have in the laws governing our nation. Furthermore, the practical implementation of such an exclusion is fraught with difficulty and risks arbitrary line drawing, potentially creating more division and injustice. The precedent it would set, segmenting voting rights based on identity, is perilous, threatening the very concept of a unified citizenry with equal rights and responsibilities. The answer to ensuring women's rights and bodily autonomy lies not in curtailing democratic participation, but in strengthening it. Through robust debate, evidence-based policy, increased representation of women in legislative bodies, and a commitment to mutual respect and understanding. Let us work within our established democratic framework to achieve justice and protect rights, rather than resorting to exclusionary measures that ultimately weaken the foundations of our shared governance. Let us uphold the indivisibility of citizenship and the sanctity of universal suffrage.
Thank you, Senator. Professor Vance, your closing statement.
Senator Thorne appeals to democratic tradition, but tradition must serve justice, not obstruct it. My argument rests on the unparalleled primacy of bodily autonomy, laws directly dictating what can and cannot occur within a person's body, particularly concerning reproductive functions unique to one sex, represent a unique category of state intervention. The lived physical reality and the potential for profound, irreversible consequences endured solely by those with female bodies demand that their voices hold ultimate authority in this specific domain. This is not about general identity politics. It is about the fundamental right to self-determination over one's own physical existence. Acknowledging the historical context, where male-dominated legislatures have frequently imposed restrictive and harmful laws upon women, necessitates considering corrective measures. Granting exclusive voting rights on these specific laws is a means of empowerment, ensuring that those whose bodies are the subject of legislation are its primary arbiters. Practical implementation, while requiring careful definition, is feasible through focused legislative scope, potentially involving specialized committees or processes, ensuring the focus remains strictly on direct bodily regulation. This is not an attack on democracy. It is a call for a more nuanced understanding of democracy, one that recognizes certain fundamental rights, like bodily integrity, may require exceptional protections to ensure substantive justice prevails over procedural formalism. True democracy safeguards the most vulnerable rights and ensures that those most profoundly impacted by a law have the decisive say. In matters concerning the intimate reality of female bodies, that means granting women the jurisdictional sovereignty they inherently deserve.
Thank you, Professor Vance and Senator Thorne, for presenting such cogent, articulate, and compelling arguments on this complex issue. You have clearly delineated the central conflict, the principles of universal democratic participation versus the unique and fundamental claims of bodily autonomy and lived experience. We hope this discussion has provided our audience with